Hello, everyone. Welcome to another live edition of Employment and Disability Law Q&A. My name is Alex Lucifero. I am an employment lawyer with Samfiru Tumarkin, LLP. I also manage the firm's Ottawa office, coming to you live from Ottawa, Ontario this afternoon. Quite a nice day, if I have to say myself. Hopefully, things are well with you. If you're tuning in right now and you're wondering what's this live stream about, who is this person in front of me? Well, I'm an employment lawyer and disability insurance lawyer as well. And this is a live Q&A. So this is an opportunity to engage with our viewers, engage with the people watching this live stream, and to answer any questions that you have related to your employment, whether it's about termination or temporary layoffs. Maybe your employer, your boss has suggested some changes at work. That's an important opportunity to speak with an employment lawyer. Or maybe you're dealing with a medical leave of absence. Maybe you have some questions about medical leaves or about disability insurance. This is the place to be if you have any concerns in that respect. Go ahead and ask your question right now, whether you're watching on Facebook or YouTube or any platform that you're watching this on. Go ahead and post your question over the next half hour. I promise I will get to your question and point you in the right direction, give you the information and the advice that you need in order to help resolve your workplace problems. It's important to note that the workplace is such a crucial aspect of our lives. We spend the majority of our time at work, and despite our best efforts, problems arise in the workplace, disputes happen. Again, whether it's a bad performance review or whether your boss is trying to change the terms of your employment, really whatever the reason, issues in the workplace come up. And as an employee in those circumstances, you need to know what your rights are. You need to know what your obligations are for that matter as well. You need to know what you can do and what you can't do in a workplace settings. And without that information, without that knowledge, the law cannot protect you. If you don't know what your rights are, there is no way that you can protect yourself when it comes to your employment. And again, that's exactly what we're here to do. We're here to educate people on what their rights are when it comes to employment law. Whether that's during the course of their employment, what an employer can and can't do while you're working with the company, and also at the end of your employment, if you're one of those unfortunate individuals. And I mentioned I'm coming to you live today from Ottawa, Ontario. In Ottawa, Shopify, the large employer, Shopify has just let go of 10% of its workforce. We have lots of employees contacting us really across all industries, wanting to know what their rights are when they're let go from their employment, particularly when it comes to severance. And again, that's what we're here to do. We're here to educate people on what their legal entitlements are when it comes to work and employment law. Before I get into a couple of things I wanted to discuss today, and so please, guys, having said all of that, go ahead and ask your questions. If you're at all curious about anything workplace related, if you have a pension issue that you want to know about, if you have an overtime issue that you want to know about, and Connor has just posted a question about overtime on our Facebook stream, please go ahead and ask your question. I think it's extremely important to get those questions out there. And the reason why is because not only will you be helping yourself in asking your question, actually getting your question answered and having a little bit more knowledge and advice about employment law, I guarantee you're also going to be helping hundreds of other individuals out there that are viewing the live stream right now or going to be viewing this at a future date, who are dealing with the exact same situation, exact same problem that you are. Again, asking your question will also help not only yourself, but those other individuals as well. Okay, before I get into all of that, a couple of pieces of contact information that I always like to give out at the start of the segment. If you want to contact us off air, if you don't want to ask your question online, or if maybe your question's or your situation is a little too complicated, here is where you can reach us. I'll start first with our website address. Our website is employmentlawyer.ca. That's employmentlawyer.ca. Very simple, easy address to remember. Go ahead and visit our website as a first step in your journey to collecting that information and that employment law advice that you need. On our website, well, of course, we've got our contact information, so you can reach us very easily just by visiting our website and seeing our contact information there. But not only that, we have a ton of articles, blog posts, news clippings that you can access that can probably give you an initial sense of your situation. For example, if you're dealing with a temporary layoff situation, let's say, for example, you've been laid off from your employment temporarily, your employer has told you to go home, we'll call you back to work when we need you. We have a ton of resources about temporary layoffs. Of course, our long-time viewers, our long-time listeners to our radio show, for example, or our TV show, for example, will know this already. But for those of you that don't know, a temporary layoff is not automatically legal. An employee has the right, actually, to either accept the layoff if they want to. I'm not sure why really an employee would want to, but you can accept the layoff as an employee if you want to, or you can actually reject the temporary layoff and treat it as a permanent termination. You wouldn't know that as an employee unless you visited our website and read up on some articles about temporary layoffs. And that is also the case when it comes to temporary layoffs related to COVID-19. So again, visit our website, a ton of stuff there, our contact information there, all of our various offices across Canada, individual lawyers, etc. Please go ahead. You can also visit pocketemploymentlawyer.ca. If you have a question about severance, let's say you've been let go and you've received a severance offer and you want to know whether it's fair or not, go ahead and visit pocketemploymentlawyer.ca. Answer a couple of questions for absolutely free. There is no charge whatsoever for this, and out will come an answer as to whether the severance offer is fair or not. You can also ask, for example, whether you've been constructively dismissed or not. You can answer a couple of questions with respect to changes to the terms of your employment, and out will come an analysis of whether you have been constructively dismissed. A constructive dismissal, for again those of you that don't know, is when an employer changes the terms of your employment so significantly that you would have the right, as an employee, you would have the option to treat your employment as terminated. It's basically a breach of contract in an employment situation. Your employer has done something so far out of the employment contract and the usual employment terms that you're allowed to treat that as a breach of contract. Again, pocketemploymentlawyer.ca is where you can answer a couple of questions for absolutely free and get the answer to those questions. Last piece of contact information, I promise, and that is our email address. And we get a ton of emails on a daily basis. And by all means, please email us with your concerns. Email us with a brief description of your situation, and we will point you in the right direction. Our email address is help@employmentlawyer.ca. You can see it on our screen right now, help@employmentlawyer.ca. Again, don't be shy. There's no charge. Go ahead and email us. Give us a brief description of your situation, and our intake team will put you in touch with an employment lawyer or with the person appropriate for your particular matter. All right, guys, for those of you just tuning in, once again, my name is Alex Lucifero, employment lawyer and disability insurance lawyer with Samfiru, Tumarkin, LLP. This is a live Q&A. Go ahead and ask your question on whichever platform you're viewing this on, and I promise I will get to answering that question and get you pointed in the right direction when it comes to your workplace situation, your workplace problem, when it comes to employment law more generally. Even if you're not dealing with a particular situation, if you just have a general question about employment law, maybe you want to know what your severance entitlements are, go ahead and let me know what your age is, how long you've been with the same employer, and what your position is, and I will give you an answer on what your severance entitlements may be. Even if you haven't been terminated yet and you're just curious, go ahead and ask that question. Okay, I see a couple of questions coming through, guys, and that's absolutely great. Please continue posting those. As soon as I've got a few questions lined up, I will get to answering them. But before that, let me talk about a matter that I alluded to just previously, and that I wanted to have a chat about only because I think it'll be a good lesson for our viewers out there. I had mentioned earlier on in the live stream that a pretty large employer here in Ottawa by the name of Shopify. Shopify is probably a company that you've all have heard of and might know quite well. Shopify recently announced that it is going to be letting go of 10% of its workforce. They're a relatively large employer, and so that's a big number of employees. And what Shopify did here is they announced, this is all kind of public record, they announced that they are going to be offering all of these employees a severance package worth 16 weeks of pay. So as a minimum amount, 16 weeks of pay plus 1 week's additional pay per year of completed service. So for example, if you're a 4-year employee, you're going to receive a 20-week severance package, 16 weeks plus 1 week for the 4 years of completed service. And we've received a ton of calls and questions and even some media requests asking us, does this make sense? Is this the way severance is calculated? Is that a fair package for employees of Shopify who have been let go? And what I've had to advise the people that I've spoken with is that really severance is not that straightforward or mathematical a calculation. There is no set mathematical formula when it comes to severance. So I can't say that it's 16 weeks plus 1 week per year of service. That's a pretty arbitrary calculation of severance that I think may very well lead to some inaccurate results. You cannot apply a mathematical formula like that, whether it's 1 or 2 weeks per year of service or 16 weeks plus a certain formula. Severance doesn't work like that. An employee's severance entitlements are based upon their age, their position, and their years of service. So the older an employee is, the longer they've been with the same employer, which effectively means the longer they've been out of the job market, and the more senior or the more specialized their position is, the more severance they're going to get. Severance can be as much as 24 months of pay, 2 years of pay for long service and perhaps more senior employees. But even for short-term employees, even if you've only been employed by the company for 1 or 2 or maybe even 3 years, if you're older or if your position is more senior, your severance entitlements might be in the range of 6 to 10 months, something like that. So to simply pick 16 weeks as a kind of general number across the board, well, listen, 16 weeks, which is just about 4 months of pay, that might work if you're a 1-year employee, who's relatively young. It's not going to work for an employee who's in their mid-50s with 8 years of service in a pretty specialized position. That employee is going to be owed 10 months of severance as compared to 16 weeks, just as an example. And so, Shopify has to be very careful here, because just applying this formula automatically across the board is going to lead to unfair results, particularly for employees with longer tenure and particularly for employees who are older with more specialized or senior positions. I can guarantee that's not going to be enough severance for those particular employees. So the lesson here for both employers, and if you're an employer, if you're a business owner that's watching this right now, keep this in mind. Severance has to be tailored to the individual employee, depending on their age, their position, their years of service, perhaps whether they signed an employment contract with contract or not. Do keep in mind that you cannot apply a severance calculation across the board to all employees. It's going to give you a headache at the end of the day, because those employees will engage an employment lawyer and negotiate a much better package, and rightfully so, based on their age, position, and years of service. On the other hand, if you're an employee and you've been let go from your job, and your employer tells you, this is what we're offering you based on our calculation and human resources determination of what's fair or not fair, this is what you're getting, whether you like it or not. Don't take your employer at their word. Make sure that you speak with an employment lawyer, that you get proper advice from a lawyer who knows what they're doing when it comes to severance, when it comes to employment law. Odds are, if your employer is applying this mathematical formula to all employees kind of generically across the board, odds are you're looking at an unfair severance package and you are going to be owed more than what your employer has offered you. I guess the good news in that respect is that it's actually relatively easy to negotiate a better severance package once you engage an employment lawyer. This is not complex stuff. This is not rocket science. The laws are very, very settled, very well established when it comes to severance packages, when it comes to employment law. And so oftentimes with very little engagement, very little interaction, a few back and forths, whether that's telephone calls or sending emails or letters, we can make sure that the employer revises its offer and offers the employee a fair package. All right, guys, that's enough about that. Again, lots of severance talk in the past week or so, only because it's been in the news lots. And listen, this is something we, of course, see across industries. Industries ebb and flow. There's, of course, a boom and bust. And of course, there's lots of talk nowadays of, recession and companies doing poorly coming out of COVID. And that is unfortunately going to lead to job losses and going to lead to severance being owed to employees. Again, if you're an employee out there and you're being let go, don't sign anything without speaking with an employment lawyer. Odds are the severance that's been offered to you is not what it should be. All right, guys, first in line, as I mentioned earlier, was Connor today. Connor, thanks for your question. Let's get to the questions, guys. And again, keep them coming. I have a few lined up here, which is absolutely great. If you haven't yet, go ahead and post your question right now. I promise I will get to it. And I promise, I don't know much about family law or criminal law. Don't ask me any questions with respect to those areas of law. But if you're dealing with a workplace situation or employment situation, or if you're just curious about what your severance entitlements are, go ahead and ask your question. Tell me your age, position, and years of service, and I promise I will answer. Connor asks, can you refuse requests to work overtime? It's an excellent question, Connor, and it's actually one we don't get very often. The short answer is yes, you can refuse requests to work overtime. There's nothing illegal or wrong with that. An employer cannot force an employee to work overtime. And this often comes up, and it becomes particularly the case when we're dealing with parents of young children or parents of children in general, and employees refusing overtime in the context of those parental obligations. So an employee will say, I'm sorry, I have to pick up my child from daycare, or I'm sorry, I have to be home to, make supper for my child, or bring my child to school, or bring them to their activities, etc., and therefore refuse to work certain hours or refuse to work overtime hours in that respect. Keep in mind, in those circumstances, an employer has to play ball. They cannot punish you. They cannot give you a hard time because you have those childcare obligations. That's potentially discrimination under human rights legislation in Ontario. It's illegal. An employer can't do it. But even setting aside the issue of parental obligations, no, Connor, an employer can't force you to do overtime. Now, the one exception here is this might differ if you're a unionized employee. I was particularly referring to non-unionized employees. If you're a unionized employee, Connor, it will really depend on the terms of your collective agreement and on ultimately what your employer and union have agreed upon. If your union and your union representative is telling you you need to work this amount of overtime, these are the hours that you have to do no matter what, it's in the collective agreement, guess what? You're bound by that collective agreement as an employee and a unionized employee, and you're going to have to do that. Otherwise, you risk your employment and you risk your relationship with your union, who, need I remind everyone, is really your one and only legal representative in an employment law context as a unionized employee. It's important to remember that. We get lots of calls, lots of emails from unionized employees, and unfortunately, we can't help them. Not because we don't want to. We'd love to help unionized employees, but because we simply can't. Legally, that's the way it works. As a unionized employee, your union is your legal representative, and you are bound by what your union decides when it comes to your employment, and you're bound by the collective agreement, which is the contract of employment between your employer and the union. Those are, that's the playing field. Those are the rules of the game, and that means that you're stuck with your union as far as your legal representative. Don't get me wrong, lots of great things about unionized employment. Great job security, better pay oftentimes, better benefits oftentimes, but we deal with a lot of unionized, or we speak to at least preliminarily, a lot of unionized employees who aren't particularly happy with their union, and unfortunately we can't assist them. Connor, hope that answers your questions. Listen, if you are dealing with an employer who is trying to force you to work overtime or giving you a hard time, maybe because you have obligations outside of work that don't allow you to work overtime, listen, give us a call, contact us offline. Let's have a chat about it. You want to be really strategic about how you respond to your employer in a situation like this. You want to be measured. You want to be reasonable. You don't want to go off the rails and get aggressive with your employer, but you do have the right to hold your ground and respectfully, of course, say no to your employer to overtime work if you can't do it. Just as a quick reminder, guys, I'll give out our contact information here. Connor, if you want to reach out to us, again, send me a quick email. help@employmentlawyer.ca is where you can contact us. That's help, HELP, @employmentlawyer.ca. You see it on the screen right now. Again, send us a quick email. I promise someone will get back to you. Otherwise, and you just saw it on the screen before, the email address, employmentlawyer.ca, is the website address. All of our contact information, phone number for our office lines, etc., are on the website. Next question, guys, and thank you very much for them. Keep them coming through. I see your questions. Jake is next in line. Stephanie, Eve, or Ev, Evie. Jake asks, on WCB claim on appeal process, but got dismissed from work. What my legal rights? Jake, so it sounds like you're dealing with a workers' compensation issue. So you were injured at work. You were mentioned an appeal process. So your claim for benefits under workers' compensation sounds like at least the initial claim was denied and you're being appealed and you've been let go from your job. I mean, there are a number of red flags there, Jake. So if you have been legitimately injured at work and you've been denied disability benefits, it's important to know why you've been denied, right? Are they claiming that you weren't injured at work or that the injury is not serious enough? Are they claiming that maybe you just filed the paperwork incorrectly or maybe you didn't file it in time? What is the specific reason for the denial? We need to figure that out and then figure out if we can address those concerns. Of course, if you're injured and you're not working, you need some sort of cash flow, right? You need some sort of disability benefits. If it's not going to come from workers' compensation, maybe it should be coming from disability insurance. So if you had short-term or long-term disability insurance, you can perhaps apply for those benefits. And in addition to that, listen, if you've then been let go from your job, that's obviously making a difficult situation even more difficult. I can tell you this, Jake, if you have been injured at work and you have then been, relatively shortly thereafter let go from your job, listen, I think we can connect those dots pretty easily. It sounds likely that you were let go from your job because you were injured, maybe because you applied for disability benefits or workers' compensation benefits. And that's a huge, huge no-no on the part of an employer. You cannot let an employee go because they've been injured. You cannot let an employee go because they've applied for workers' compensation. That's discrimination. It's discrimination in the Human Rights Code. It's also potentially a violation, at least in Ontario, it's a violation of the rules regarding workers' compensation and returning back to work. And so your employer may be in big trouble for that reason. Jake, you might be owed severance, but not only severance, you might be owed additional damages beyond that in a circumstance like that. Listen, if you haven't already, and if you are in British Columbia or Alberta or Ontario, those are 3 provinces in Canada, and this is your situation, Jake, please give us a call at the office. Send us an email at help@employmentlawyer.ca. You need to speak with an employment lawyer immediately. We need to get into the details of your situation. What exactly happened? Again, why were you denied the workers' compensation and you're appealing? Why did your employer let you go? That sounds off if you're in that situation, if you're dealing with a disability or dealing with an injury from work. Let's get to the bottom of those questions and let's make sure you get the proper compensation that you're owed and make sure that you are, either get some sort of settlement from the company or get your disability benefits, perhaps get you back to work and get you moving forward with your life. All right, Bruce, a bit of a funny one here, but I'll address it because Bruce, I can assure you, and perhaps as you might expect, this is not the first time I've been asked this question. Bruce, funnily asks, have you considered that last name basically means devil, Lucifero. Yes, my last name is Lucifero. And I guess if you take out the O, it does mean Lucifer. And I've heard that joke before. And I've heard it all sorts of ways. Bruce, thanks for the observation. Yeah, that's about all I'll say about that. Stephanie asks, my husband was recently laid off. He was the only one who was told shortage of work. When I was looking on Indeed, I found the job posting for his job at the company he worked for, and they were posted about a week before he was laid off. Can the company do this? Stephanie, what a great question. Thank you so much. I guess a couple of points in this respect. So first off, it needs to be said, Stephanie, yes, a company can probably do this. A company can let an employee go, pay them the proper amount of severance, and replace them, and post a job posting for the exact same job afterwards. There's nothing inherently illegal about that. As an employer, and listen, think about it like a personal relationship. As an employer, you can decide to break up with the employee. You can decide to end the relationship. There's nothing illegal about that, even if you're simply looking to hire someone else to do the exact same job. There's nothing wrong with that. As long as, and here is the legal catch for your husband, Stephanie, as long as he's been paid the proper amount of severance. And this is what we oftentimes see, that employees are let go, even in this situation where they're being replaced, but they haven't been offered the proper amount of severance. The fact that they're being replaced is not what's legally actionable there. What's legally actionable is whether your husband has been offered the correct amount of severance or not. That's point number one. I get it. It's a difficult pill to swallow. Don't get me wrong. Sometimes it could feel very unfair. For example, an employer can let, for example, your husband go and rehire someone whom they can pay less for the exact same job. Right? But again, there's nothing illegal about that. An employer is allowed to do that as long as the correct amount of severance is paid. Now, the one exception to that rule, Stephanie, is if we're dealing with a human rights ground. So, for example, if your husband was let go and replaced because the employer thinks he's too old to do the job, or if he's being replaced in his job because of his religion or gender or nationality or ethnicity, or maybe because of childcare obligations, those are all protected grounds under human rights legislation. You cannot let an employee go or replace an employee on one of those grounds. That is, again, a human rights violation. So that's the one exception, Stephanie. And if your husband thinks that he was let go for any one of those reasons, yes, of course, that's a problem. But barring those grounds, barring those kinds of situations, it is not illegal for an employer to let an employee go and replace them in their position and post a new job for the exact same position, again, provided the correct amount of severance is paid. All right, rapid fire, guys. Last couple of questions. I've got a couple of minutes here. EV asks, if pre-litigation attempts have failed and a new agreement is required for litigation, is it normal to continue as a contingency agreement? You're talking about fees here, Eve, and I think what you're referring to is in a situation where maybe some attempted negotiations fail and you have to actually sue an employer, start legal action against an employer in a situation like that. It is certainly common that fee structures can change based upon where you're at in the resolution process. So oftentimes, as far as our firm goes, this is not the case for every employment lawyer or every law firm, certainly, but we can structure our fee arrangements where we will not charge an hourly rate. We will not require any kind of deposit or retainer from an employee. We will only charge an employee if we can actually successfully resolve the matter for them. And our fee would be a percentage of the settlement that we achieve or the increase that we achieve on any severance package. However, it is possible, EV, that arrangement can change if you actually have to start formal litigation. Oftentimes there are court fees involved, there are mediation costs involved, there are lots of kind of hard costs involved that mean that fee structure might have to change. It's not uncommon at all, to answer your question. All right, last minute, guys, just going a little overtime here, but I'll get to the question only because he is a frequent viewer and frequent question asker, or she rather, JC 2004 I'm referring to. And we appreciate the loyalty, and so I'll get to that question. JC 2004 asks, if you work in a workplace where a second shift comes in, who would be responsible for taking over, and you have no keys locked up, are you then forced into working overtime, or can you simply just go? That's assuming you can't get a hold of a supervisor. I don't know how often, if ever, people have to deal with that. I figured it would tie in with the forced overtime. Listen, JC, I think reasonableness has to prevail here. If you are the only employee on a work shift and you're waiting for the other person on kind of the next shift to come in and they are late, listen, I think in a lot of cases, again, reasonableness and a certain level of responsibility have to prevail. If you can, if it's not an emergency situation, I would wait for that next person to come in. I wouldn't just walk away. Again, there's no particular legalities about the situation, but certainly I think that makes good sense. If this becomes a trend, if this becomes a habit, if this particular employee who's working this next shift is constantly late, I think you need to bring that to your employer's attention, and it needs to be addressed, right? You can't be taken advantage of in a situation like that. But if it's a one-off situation, don't just skip out on your employer. Do them a favor. This is a relationship. Remember, guys, an employer-employee relationship is one that needs to be fostered. There needs to be goodwill on both sides. You can score points and be in good favor with your employer if you're doing them a favor in that respect. I think that's the right answer to your question, JC. Thank you all so much for tuning in. Once again, this has been an Employment and Disability Insurance Live Q&A. Signing out for today. Again, my name is Alex Lucifero. Thank you so much for asking your questions. Thank you all so much for watching. I wish you a great rest of the week and an excellent weekend. We will catch you here next time, early next week. Until then, take care, everyone, and so long.